of a lifetime spent trying to avoid what my colleagues disparagingly call boys' history, and thus despise. It's partly, I think, because I count amongst my early significant experiences and influences the work of H.J. Hewitt, whose books on the Black Prince's expedition in 1355 and later on the organisation of war under Edward III, as well as on medieval Cheshire, of course, I read actually for pleasure rather than, as a scholar does these days, to fill it and gut the footnotes and conclusions. Now, Hewitt, I think, was almost completely wrong about medieval Cheshire, but right, I think, in emphasising what nowadays would be called the importance of the logistics of warfare. That is, the business of preparation and getting there. And although Philippe Contamines justifiably regarded great work, is nowadays seen and fashionably cited as the fount of modern interest in la sociologie de la guerre, it was, I think, Hewitt who was far more widely read in England than Contamine. Certainly I never met very many people at the time with whom I could discuss Contamine's conclusions. And I remember when I did discuss them with the late John Roskell, his only comment was, oh dear, oh dear, oh dear. So I think in introducing this topic, I need to set it in that sort of historiographical context and worry about the normal processes of military recruitment, that is the preparation for going to war, which of course was usually by indenture and muster, usually of retinues of varying sizes, a process which has produced a voluminous record amongst the National Archives and is, of course, the basis of the Soldiering Later Medieval England project, which was based here. Soldiers so raised might appear in other contingent records as they sought letters of protection and attorney for the duration of their service or received later payments and rewards. But the complete record is essentially nominal. Itself, the guarantee of a kind of anonymity which historians of manorial records in the English peasantry often complain. And it's predicated, of course, on the involvement of the state. But having contracted with the Crown, a captain often raised his own forces on the back of different solidarities in local society, the communities of the estate, the parish, the neighbourhood, and within his kin group, his wider affinity. Urban communities, meeting the demands of the Crown, seem, interestingly, to have acted in much the same fashion. And English armies, at least before the 15th century, to that extent, had reflected the local societies from which they were drawn, and at the level beneath the indenture might be supposed to have had no need of written record. Yet a process of subcontracting, whereby a captain further dispersed his obligations to a greater lord or to other lesser men, may have been widespread and may have reached to the level of the single archer, as Gary Baker's recent thesis shows. Hugh Shirley, the Derbyshire knight killed at Shrewsbury, certainly drawn up formal indentures in London for the service of 2 archers to join him on John of Gaunt's campaign in Spain in 1386. And John Lord Audley, who had indented to garrison the lordship of Brecon in 1404, had subcontracted the recruitment of archers to Peter Wilbraham, Esquire, because he later sued the 3 archers who had received their 6 months' pay at Twemlow in Cheshire for desertion. The difficulties of guaranteeing such contracts of service, which were beginning to replace these solidarities of local communities, produced other solutions, notably the use of bonds. And soldiers serving for pay may have been more prone to desertion than others, so bonds became a solution. The experience of John Mescow, a knight of Spain, may not therefore be untypical. He'd contracted with Richard Boston of Southwark a joiner to provide an archer for 6 months in Normandy. But the man so recruited, a man called John Marshall, deserted on disembarkation, and Mesco had petitioned the Chancellor for payment of Boston's high bond of 10 marks. This continues throughout the 15th century, so that at the end of that century, in 1475, Sir Ralph Ashton of Middleton, in Lancashire, who'd indented to serve with Richard, Duke of Gloucester, on Edward IV's invasion of France, demanded a letter of obligation of £20 from Robert Lee, Letitia Holt and her son Christopher, the letters to be void if Lee served well and ably arrayed as it appertaineth to an archer doing the king's service for a year from the date of the muster on the 26th of May and taking 6pence a day for his wages. These arrangements, of course, have been seen as pointing to the rise of what Andrew last night was calling a professional soldiery and the breakdown of the personal bond between a captain and his retinue. But whatever the balance between locality and professional service, there's an unspoken assumption of voluntarism in which men served without compulsion and for pay and other contingent rewards. But one of my recent thoughts is that these kinds of attractions can seldom have covered costs. The more we learn about the business of equipping oneself for war, the more that participation in war, like participation in the crusade, seems to have been a costly exercise. While there were profits to be had from service, the springs to that service may have lain elsewhere. Service in war may have been a cultural rather than an economic commitment. Andrew last night stressed the potential rewards, the profits of a naval campaign in the 1370s, but was also drawing attention in the later part of the 14th century of an increase in the upfront weighting of recruitment in the matter of regards and payments made, as if people had to be enticed to take on the financial commitments. The English gentry may have been committed to warfare to an extraordinary degree, but they seem to have had to have borne large costs. And amongst those costs, of course, was the business of ensuring protection, legally speaking, during one's absence. Now, the early development of this process, the issue of letters of protection, is summarised in a number of works, and I'll start with Michael Prestwich's. And it's interesting there that it's accompanied by 2 telling asides. The central hypothesis of these asides is the juxtaposition of events which, were they to appear in an undergraduate essay, one would simply say that these are moored in suggestive proximity to each other, but not necessarily linked. He argues, therefore, that following the Fourth Lateran Council, or as it appears in undergraduate essays due to the influences of Spellchecker, the Fourth Latrine Council, he argues that the privileges according to crusaders were extended by the Crown to its own soldiers on military campaigns. Michael's comment is that it's not clear about the association between these 2 facts. Secondly, he asks, who had to pay for letters of protection? He concludes, this is not apparent. So it seems to me that that's an interesting point to start. We're not sure entirely about the origin of these legal instruments, nor are we entirely sure who had to pay for them. The earliest study, of course, of these is not associated with our normal interest in warfare, but with the 13th century crusade and the participation of English soldiers. So it's Simon Lloyd who's frequently cited in this connection, and it's he who talks about the development of crusaders' privileges, and implies that these privileges, and particularly the notion that there should not merely be protection of one's lands and tenants when one was absent on warfare, but also a legal protection that stopped people from suing you whilst you were away, that these may have come into being during the early 13th century. Now, the costs are interesting at this stage. In the late 12th century, the fee for a protection was somewhere in the region of 2 shillings, but was often exceeded, and in those records from the later 13th century, figures as high as 10 and 20 marks are recorded, sometimes depending upon the status of the person being granted the letters. Who actually was responsible for the issue of letters of protection is equally interesting. The assumption made in most recent projects is that these are entirely the responsibility of a retinue captain. In other words, the retinue captain submits a list of people in his company, and letters of protection are therefore issued in blocks. Letters of attorney, that is, the system whereby something more practical is offered to a soldier departing on an expedition, may have been connected some of the time, but not all of the time. Sometimes letters of attorney are listed together with protections, but sometimes quite independently. Simon Lloyd suggests that the process, that is the appointment or the enrolment in chancery of attorneys with general powers, usually is on the basis of one of them being a kinsman or friend, the second being another trained in the law. Now, if we think about this process in a broader context, that is, what it is that a soldier has to do before departing upon a military campaign, we have the process of recruitment, the process of the issue of protections of different sorts, legal and otherwise, and of course, if sensible, the drawing up of a will. But if we look at the prosopagraphical record, we seldom have all the instruments together for one soldier. So if I take the example of Sir William Mannering, we have a will of 1394, a testament of 1395, a non-cupative will of 1399, but no letters of attorney, and in fact no letters of protection for his career. So all of these sorts of thoughts lead me to think that some of these sources are worth looking at in more detail. Letters of attorney and letters of protection are, of course, now part of the list business, the database business. They appear on the soldier database and all the rest of it, and we know something about their numbers. We know, for example, that letters of attorney were issued at a much lesser rate than letters of protection, perhaps a third as many letters of attorney as protection in the later part of the 14th century, but sometimes declining to only 10% in the decade before Agincourt. In the period between 1368 and 1453, some 5,100 letters of attorney were issued, compared to 19,000 letters of protection. Now, the process of obtaining letters of attorney and letters of protection is reasonably well understood. Early studies of administrative record keeping, the role of the English Chancery, and the way that they're enrolled. But of course there are difficulties in us studying it. That is, that the nominal database lists that are used never include the names of the attorneys. So we know the people who get protections and we know the retinues, but that other part of the relationship, that is the enrolment of private agreements to appoint attorneys, we don't have a list for. We have to go back to the rolls. It's evident that we're dealing with a four-way relationship that is crucial to the business of going to war. If you take the resumption of the war in 1370 in the retinue of John of Gaunt, the relevant Gascon roll enrolls a long series of protections and some attorneys. Gaunt's retinue included Sir Thomas Roos of Helmsley. No muster roll survives, but letters of attorney and protection reveal something of the shape of this Yorkshire knight. One of the knight's attorneys was Henry Coddington, sometimes listed simply as a clerk, once as the parson of the church of Bottisford. Coddington and Bottisford are adjacent or nearby townships on the Nottinghamshire-Leicestershire border. But Coddington was in fact a long-standing chancery clerk at this date. So the connection with Roos of Helmsley was not in the provinces, but in London. The man who received the letters of attorney, and it was necessary to receive letters of attorney at the Chancery in London, was Walter Power. Coddington and Power were both members of John of Gaunt's wider affinity. Now, that model, when one looks at the Gascon rolls, is very well established. That is to say, letters of attorney require the presence of the attorneys and presumably, therefore, the soldier in London. And that seems to me an important point to make, that the organisation of war, in terms of the organisation of protections and attorneys, the legal business, required the attendance of the soldier in London. And the centralising magnetism of London in terms of the logistics of warfare, whether it's the purchase of armour, whether it's the organisation of subcontracting for archers, whether it's the business of ensuring legal protection, seems to have gone very largely through London. The personnel of attorneys, when one examines the detail of them, are dominated by the royal administration in London. So relationships between knights and their legal protectors are formed almost exclusively in London. And I'll finish by suggesting that this ought to be more studied, and finish by drawing your attention to a very famous piece of evidence. In the case before the Court of Chivalry in 1386, between Sir Richard Scrope and Sir Robert Grosvenor, the poet Geoffrey Chaucer gave evidence. If you remember, Scrope and Grosvenor had arrived at the campaign in Scotland in 1385, bearing the same arms as your bend or, and had been challenged. Chaucer's evidence, being asked whether he had ever heard of any interruption or challenge made by Sir Robert Grosvenor or his ancestors, said no. But he was once in Friday Street in London, and walking through the street he observed a new sign hanging out with these arms, and inquired what inn was that hung out these arms of Scrope. And one answered him, saying, "They are not hung out, sir, for the arms of Scrope, nor painted there for those arms, but they are painted and put there by a knight of the county of Chester called Sir Robert Grosvenor." And that this was the first time he had heard speak of Grosvenor or his ancestors, or of anyone bearing the name of Grosvenor. What was Grosvenor doing in London? He had no need to be there as a Cheshire knight going on campaign in Scotland. He had not any record of earlier military service since 1372, so unless Chaucer's testimony is actually retrospective by a good number of years, we must assume that what Grosvenor is doing in London is making preparations for the campaign in Scotland in 1385. So a Cheshire retinue might find its leadership drawn to London, even though its destination of march was to the north of the capital. We need, I think, to spend more time worrying about the connections between soldiers and their attorneys, to get behind, if you like, the terms of an indenture of retinue of March 1443 between Thomas Alcomloe and members of the Mannering family, following the Mannerings' recruitment by Humphrey, Duke of Buckingham, a couple of years earlier, when the Earl was serving as captain of Calais. Alcomloe was retained for life to give service with pen, ink and counsel. The assumption must be that he's being appointed as an attorney, and he is therefore a central figure in the formation of the military retinue, and one whose importance and interest we ought further to explore. Thank you.